Well, the Office of the Solicitor General says it acknowledges the concerns regarding the representation of previously disadvantaged individuals within the legal profession. This comes after Justice Mandlenkosi Motha made a public call for diversity among legal practitioners. He says there is a critical need for transformation within our legal system. In responding to these concerns, the Office of the Solicitor General has committed to fostering a legal profession that reflects the principles of diversity, inclusion and equity. For more on this, we now speak to the Solicitor General, Fhedzisani, Pandelani, who's joining us live. Good morning, SG. Thank you so much for making time for us. I want to go to the part where there is a call for strengthening monitoring with regards to the briefs that are being given to counsel. Wasn't the monitoring mechanism already there in place? Because our Constitution, the preamble of the Constitution, already says that we recognize the injustices of the past.
Thank you very much, Aldrin, for having me. As you would know, the Office of the Solicitor General is fairly new. I think it came into being in 2020. So if you're referring to monitoring systems, there was nothing in that space as at the time when the Office of the Solicitor General started operating. We're talking here about, when you talk about state litigation, you're talking about almost 35 national government departments, 136 provincial departments, as well as 257 municipalities. And that is discounting the 704 SOEs, boards and entities. And in fact, it is very disturbing that up to so far, you would still have a huge outcry about briefing patterns. When I came into this space, one of the major concerns was that the briefing patterns were inimical. There was over-briefing in certain parts, and in others, people were never actually looked at all. You would actually have the number of firms in South Africa. There are 6 top legal firms. You've got medium-sized and small. And those that are at the bottom rank were never looked at. So there were no systems at all.
No systems at all. So now that the SG is speaking about the robust monitoring and reporting mechanisms that will be put in place, what does this look like?
Well, one of the critical chapters that I've had to deal with as part of my mandate in crafting the policies that are envisaged in terms of the State Attorneys Amendment Act 13 of 2014 is a policy called Briefing and Outsourcing of State Legal Work. And that policy is anchored on the provisions of Section 217 of the Constitution. Equally, there is something called the Legal Sector Code, which seeks to also deal with entities that are outside of government. You will appreciate, Aldrin, that, when government departments litigate, they litigate at the back of a vote which is meant for service delivery. So it is circumstantial that they've got to brief. But when they do, it must be fair, it must be transparent, it must be inclusive of everybody else that renders state legal services.
Yeah. I wonder then whether the BBEE legal sector code could bring about the transformation that is envisaged. A couple of organizations, including the Black Conveyancers Association and the Pan-African Bar Association of South Africa, have called on the Minister of Trade, Industry and Competition, Ibrahim Patel, to gazette the BBEE legal sector code. From the SG side, do you think that this will make some difference towards the transformation that is being sought in this sector? Interestingly, Aldrin, I've been cited in that application, but I've been part of the team that has formulated the legal sector code. And I think the team itself is frustrated because from 2020, 2021 up to now, there's not been gazetting of that piece of work that, in fact, has been consulted widely with the legal practitioners. So I'm hoping that it will, in fact, give traction to, leveling the playing fields. If you look at the briefing and outsourcing of state legal work, which, in fact, concerns only the state,
one of the clauses, the last bit says, where there are inconsistencies between the legal sector code and the briefing and outsourcing of state legal work, the legal sector code shall prevail. Now, you cannot actually have a functional briefing and outsourcing of state legal work if you don't also action the legal sector code. So in my view, those two instruments are very critical in making sure that there is transformation in this space.
Have you had an opportunity to speak to Minister Patel why there is the delay in gazetting the BBEE legal sector code?
Aldrin, I think that is above my weight. The only person that, in fact, has got the necessary gravitas or stature to speak to his colleague will be the Minister of Justice. I've not actually consulted with him as at the time of this interview, but he's aware of the court action that has been, in fact, commenced. He is also one of the respondents, and we will actually also be filing our papers. But as you can expect, I think both the Minister and I might, and I'm actually saying this unequivocally so, might actually have to file notices to abide with any court decision that ensues from the litigation.
Yeah, but otherwise what you would actually want is for this BBEE sector code to be given to actually be gazetted.
It's long overdue, honestly speaking. I cannot completely fulfill my mandate as the Solicitor General only with one instrument, which is briefing and outsourcing, without infusing some of the benefits that could be derived from the legal sector code, because I also need to be subjected to what we call the Charter Council that will be established with the gazetting of the legal sector code. So if you really need oversight on how we brief as the state, and I'm satisfied that we are in fact trying by all means in the past 3 years, to effect changes in this space. But until and unless the legal sector code is gazetted, everything else that we try to do will not in fact have any impact as it is envisaged in the legal sector code.
Okay, another part to the transformation conversation and inclusion conversation is briefings issued to women legal practitioners, and we've seen that there has been the targets that have been met and sometimes the targets being surpassed. But then the issue is around the value of those briefings that are being received by women legal practitioners, and we've seen that there has been a slight decline. Why is that?
Well, look, sometimes it also, most of the female legal practitioners would be your junior advocates that in fact will be assisting the senior counsels. So we need to change that landscape. We need to in fact empower quite a number of our women practitioners so that they can stand on their own. There are a few senior counsels that are female, and that also goes with the amount of money that you can command in that space. So the figures or the value is actually predicated on the level that most of our age that landscape. We need to empower them more. We need to insist that they must actually be trained in some of the critical briefs that we issue out as the state.
Yeah, and still staying on the briefs for previously disadvantaged individuals, I see it just goes over 1 billion rand. But what is the total amount of money that the state attorney would have spent on litigation in total, outside of just looking at the previously disadvantaged individuals?
Well, look, I think we are now, I think the figures would have been as at end of Q3, which in fact would have ended up in December. When I was actually collating the further invoices that ought to be paid before the end of March, we're looking at an additional 1.5 billion rand or thereabouts, which means that we would have spent just roughly under 3 billion rand for the current financial year. But if you look at bar the COVID period, where there was not so much litigation, if you look at a 3-year period, we in fact spent on average about 7 billion rand in protecting the interests of state, in relation to litigation. And we're trying to change that because some of the policies that have been approved by Cabinet seeks to do away with litigation as a first resort, meaning in all matters that are preferred against the state, it is going to be instructive for those that consume state legal services to try and attempt mediation to start with. If you may, quite often when you need to prefer a claim against the state, you need to in fact notify it by way of a letter of demand. And I've actually come to realize that those letters of demand are never taken seriously until such time that summons are issued. And even when summons are issued, we wait until such time that the matter is set down before court. And we settle at the doorsteps of the court. And that must be a thing of the past because there's a policy called, alternative dispute resolution, which is instructive to all accounting officers and legal managers within government to, when you receive the letter of demand in terms of commencement of certain proceedings against organs of state, it is required that the first attempt will have to reach out to the person that has issued that letter of demand and try to sit down and see whether we can, in fact, find each other before even summons are issued. So we might actually be reducing the total ballooning litigation cost against the state. All right.
And finally, SG, the conversation that actually brought us here is what happened and what Judge Motha had to say. I wonder whether you have had an opportunity now to speak to the head of the State Attorney's Office in Pretoria about his remarks and also how he handled the entire situation.
I have, Aldrin. I think we've been interrogating this issue. We will be having a meeting of all 13 offices of State Attorney, including the State Attorney in Pretoria, so that we can, in fact, speak with one voice when it comes to standard operating procedures. In this instance, I think a junior attorney was allowed or was left at his own devices. The deputy state attorney was not available. He was dealing with the ICJ Palestine-Israel matter and he was not contactable. The head of office, as at that stage when that document was filed in court, was busy addressing correctional services on other matters of litigation. And because of the timelines, I'm told that the junior attorney, in fact, found himself with no option. But let me be frank with you, Aldrin. What worries me most is that whilst we accept that the advocates that were engaged to represent the Black Economic Empowerment Commission had refused to cooperate with the judge, the same reasons that they published found themselves in the heads of argument that have been filed by this junior attorney. And that, in fact, is one issue that worries me so much. Yeah. And I'm interrogating the issue whether that particular head of argument or whatever you call it really emanated from the state attorney's office or whether, it was contrived and put inside the heads of argument and filed in order to register a message. It is, uncharacteristic of the office of the state attorney in Pretoria to behave.
Will there be investigation around that?
I'm really checking on that. I've
right.
actually requested to be told whether indeed, it was cut, copy and paste of certain things that have already been canvassed elsewhere. But of course, that is an internal administrative issue. But the answer to your question is that it's a junior attorney that, in fact, found himself without any supervision that, in fact, had to file that statement. The question as to whether he copied and pasted and served that document in court is an issue that we will administratively deal with internally.
Thank you so much for your time. That is Fhedzisani Pandelani, who is the Solicitor General of the country on diversity and gender transformation within the legal profession.